Hello everyone, I am Anuj Nakade and welcome to LiveLaw. This video is an update in the petition filed by comedian Kunal Kamra and the Editors Guild India and Association of Indian Magazines in the Bombay High Court against the new 2023 amendments to the IT rules, specifically the Information Technology Intermediary Guidelines and Digital Media Ethics Code Amendments Rule. As you know, freedom of expression being extended to discourse and content creation on the internet is a consequential part of freedom of speech today. Given the real-time instantaneous connectivity provided by the internet, in these circumstances, regulating speech on the internet, while in some ways is a necessary consideration, is not without significant debate. In fact, this very video is made possible because of freedom of speech and expression we enjoy over the internet. This is where the IT rules come in. The IT Act and the IT rules have been made by the Indian government to regulate and govern the use of information technology in the country. However, as we mentioned, it is not without significant debate. Previous amendments to the IT rules have already said that intermediaries such as Twitter, Instagram, YouTube, or Threads are liable for the content that is published on their platforms and must take down objectionable content upon government orders. In April of 2023, the Ministry of Electronics and Technology of the Government of India notified new amendments. These amendments give the power to the ministry to notify a fact-check unit of the central government to identify fake or false or misleading content online in respect of any business of the central government. Rule 3 also adds a new due diligence under these rules, compelling the social media intermediaries and telecom service providers to inform users to not host, display, upload, modify, publish, transmit, store, update, or share any information in respect of any business of the central government that is identified as fake or false or misleading by such fact-check unit. Violation of this rule can lead to the social media intermediaries losing their safe harbor immunity under Section 79(1) of the IT Act. Soon after the notification of the amendment, Kunal Kamra moved the Bombay High Court against this amendment. His petition challenges Rule 312A and Rule 315 of the IT rules, and the argument is that as per these rules, social media intermediaries are directed to make reasonable efforts to cause their users through rules, regulations, and policies not to host, display, upload, modify, publish, transmit, store, update, or share any information which is identified as fake or false or misleading by a fact-check unit of the central government in respect of any business of the central government. The plea he has made says that these rules violate the right to equality and the right to freedom of speech and expression provided under the Constitution of India. Apurva from our team has made a video previously about this case, and the contentions of Kunal Kamra in this petition are mentioned in that video. We will leave a link down in the description so you can watch that video as well. During a hearing in April, the Bombay High Court observed that the new amendment of the IT rules prima facie lacks the necessary safeguards to protect satire. The central government had claimed in court that it would be in public interest for authentic information to be ascertained and disseminated after fact-checking by a government agency so that potential harm to the public at large can be contained. In June of 2023, the Editors Guild of India, an association that works towards protecting the freedom of press, as well as the Association of Indian Magazines, filed a separate petition to challenge the amendments of the IT rules. While the petition filed by Kunal Kamra primarily concerns the rights of a satirist under Article 19(1)(g) of the Constitution of India, AIM's plea specifically highlights the rule's implications on the press freedom and citizens' right to know. A two-judge bench of Justice G.S. Patel and Justice Neela Gokhale was already hearing the Kunal Kamra petition, and that the court listed them together. Justice Patel said, and I quote, "Since there are 3 petitions, we will not permit repeated arguments," before listing the matter to be heard in July. On Wednesday, the 13th of July, senior advocate Navroz Sirvai appeared for comedian Kunal Kamra and submitted, I quote, "It is the FCU's power to decide within this mythical binary of false and true which is the problem." To illustrate his point, he used the example of satire, saying, and I quote, "The fundamental trick of satire is to hoodwink the public to believe what is actually false to be true, and then they realize that they have made a fool of themselves and laugh and go home. This rule will completely destroy satire. He also argued that even if the objective of the rule were legitimate, the carving out of the central government as a sole member of a class, information about which will be subject to process of verification, would amount to illegitimate and invalid class legislation. He said, and I quote, "The government must justify why it is a class on its own. But the government offers no justification as to why any fake news regarding the business of the central government is on a different footing. It provides no evidence to show that there is more speculation regarding the government. There is no explanation for why it doesn't apply to state governments, statutory authorities, etc." Sirvai also submitted that no notice is proposed to be given to the party affected by the FCU when it concludes that some information about the central government is false or misleading, nor any reason for the conclusion will be disclosed. And he argued, and I quote, "It violates the principle that no man shall be a judge in his own cause, as well as that which requires the other side to be heard as well." Advocate Shadan Farsad, appearing for the Editors Guild, argued that the impugned rule infringed both the freedom of speech and expression under Article 19(1)(a) of the Constitution and the freedom of occupation, trade or business under Article 9(1)(g). On the issue of safe harbor, Farsad said, and I quote, "The effect of the rule is that if the government disagrees with an editor's content, the safe harbor will automatically be lost." The judge also pointed out that this rule would affect digital media, saying, "This amendment is limited to digital media. Could you have done this with print? Many have the same content in print and online. Can the same content go to print but be called fake, false or misleading when posted online? Fake news is about the content, not the medium." He asked, how have they addressed the divide between the online and the print media? The effect, Farsad further told the bench, and I quote, "will be to give the loudest mic to the conformist voices." His argument went further to say that what will be in wide circulation will be news that has received the government seal of approval, and the masses who consume news through digital medium will be deprived of any other news. Yesterday, on the 14th of July, Advocate Gautam Bhatia appeared for the Association of Indian Magazines. In his arguments, Advocate Gautam Bhatia referred to a South African case where their public prosecutor investigated some extravagant improvements in the then President Jacob Zuma's private house. He then released a report regarding the irregularities in the use of public funds without directly implicating the President. However, the opposition party, Democratic Alliance, circulated an SMS to voters that said that the President has misused public money. The African National Congress approached the Johannesburg High Court against this SMS. The Johannesburg High Court dismissed the case, observing that the SMS constituted a fair comment. However, the Electoral Court reversed this judgment and asked the Democratic Alliance, the opposition party, to send SMSs to rectify their earlier message. Then, an appeal was filed by the Democratic Alliance in the Constitutional Court, and the judges of the Constitutional Court delivered 3 different judgments. The Electoral Court's order directing them to send SMSs to rectify their earlier message was set aside. However, the court could not reach a unanimous decision on whether saying that the President Jacob Zuma stole money for his house is a valid factual statement or an invalid factual statement, or a valid opinion or an invalid opinion. He then used this illustration to explain to the court that political speech is a very wide spectrum and consists of more than one communication that reasonable people may disagree with or over. A fact-checking unit cannot be appointed to determine a binary of truth and falsehood. He said, and I quote, "Over 3 courts, among multiple very reasonable judges, no one could agree on even what kind of statement this was. There is a very wide spectrum of a political speech, magazine covers that reasonable people can disagree with. If even Constitutional Court judges can disagree, one can imagine the situation where a government fact-checking unit is put in charge to determine what is a falsehood." On the issue of proportionality in restrictions, Bhatia argued that the centre has the burden to show why a less restrictive way to check fake news is not adopted. Bhatia concluded, his arguments by submitting that the amendment has an indirect element of coercion, as an intermediary's commercial interest will not be served in the court if safe harbor is lost. Senior advocate Arvind Datar appeared for New Broadcast and Digital Media Association, consisting of 27 TV companies having 105 channels. He submitted that the IT rules already provide a 3-tier grievance redressal system, and the centre's affidavit does not show why a fast-track executive and arbitrary method in the form of FCU is needed when there is already a system in place. The player is becoming the umpire, Senior Advocate Datar remarked, referring to the court's earlier remark that the government is a participant in the democracy. The remark made by Justice G.S. Patel was, and I quote, "In a democratic process, the essence of which is discourse, government itself is a participant. It is not the repository of truth that cannot be questioned. Forget the fundamental right to lie, it is the citizen's right to doubt, question the government, and it has to answer. The power here of the FCU, it's very difficult." Senior Advocate Datar further added to his argument that controlling the news is very dangerous. He said, and I quote, "This obsession with regulating everything today, everyone is relying on social media for news. To be able to control such news through these rules, that is the danger." The court is still hearing this matter, and we are dedicated to bringing you updates about it. You can always follow us on Twitter for live coverage or visit our website for timely updates at www.livelaw.in. You can also subscribe to our channel and hit the bell icon for notifications. Don't forget to like the video and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. Thank you.